Good morning, and thank you for joining me on the Path to Liberty. This is the Fast Friday edition of the show for September 25th, 2020. And on this episode, I'm going to explore the important question of who decides constitutionality, specifically James Madison's view, which couldn't be further from the judicial supremacy approach of today. First of all, before getting to that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. Our show homepage is where you can get everything you need to follow the show and support the TAC at the same time. All the platforms are on, all our social media channels, our email newsletter, all the archives of the show, and on individual episodes, I include a bunch of links for you to read and learn more on your own time. And you can even find our membership program where you can put your financial faith behind our work for as little as $2 a month. All that info and more over at 10thamendmentcenter.com/path to liberty. It's all spelled out. And I couldn't be more grateful for you spending some of your time with me today. Thank you so much for being here. But since it's Fast Friday, I promise to not take up too much of your time. Let's see if I can get this done in the next 10 to 15 minutes-ish. And I want to start out with a great article by a guy named Michael Stokes Paulson. And he starts out by asking this important question. The answer to the question, of course, who interprets, he says, is most everyone today would agree, the Supreme Court. Of course, anyone you talk to about this, you say, who decides what is constitutional or not? It's the Supreme Court. They have final say, all said and done, and that's it. He goes on, and he says, and once the question of interpretive power is resolved in favor of a supreme judiciary, the question of interpretive method tends to be answered in terms of deference to, and he highlights this, whatever the supreme judiciary decides. And this line is pretty great. Paulson writes, the judicial power, quote, to say what the law is, thus rapidly degenerates into the cynical view that the law is what the judges say it is. And I first heard this type of phrase from Kevin Gutzman a number of years ago. If you haven't heard his conversation on the Supreme Court with Tom Woods on Tom Woods' show or Brian McClanahan's episodes of this week, you should definitely check those out. But anyways, Gutzman would always say, hey, the way what we live under today, you basically have the Constitution means what the Supreme Court tells us it means until it changes its mind. Paulson goes further, though. He says, thus, the twin pillars of American constitutional practice today have become judicial supremacy and interpretive license. The power of constitutional interpretation is exercised by a supreme judiciary according to interpretive criteria of the judge's own choice. This is really an oligarchy, something we were warned out a long time ago. Now, none of this could be further from James Madison's view. Here's what he had to say in Federalist number 48, talking about separations of powers, for example. He says, oh, actually, this is Federalist 49. He says, the several departments being perfectly coordinate by the terms of their common commission, none of them, it is evident, can pretend to an exclusive or superior right of settling the boundaries between their respective powers. No branch, executive, legislative, or judicial, and then we can add the states. We're going to get to the states in a little bit, but none of them have superior authority to determine the limits or the bounds of each branch or any of the branches, and that includes the judicial branch. Now, Madison was actually very consistent on this. I mean, maybe he flip-flopped a little bit here and there, but he was very consistent about this over a number of years throughout his career. And here he is in the first Congress, June 17th, 1789. He says, I beg to know upon what principle it can be contended that any one department draws from the Constitution greater powers than another in marking out the limits of the powers of the several departments. How can any department, how can any branch of the federal government, Madison asks, have a greater authority in the boundaries of the Constitution, determining the boundaries of the Constitution than the others? It just doesn't exist. He says, if the constitutional boundary of either be brought into question, I do not see that any one of these independent departments has more right than another to declare their sentiments on that point. And back to the Federalist Papers. Here's Federalist 48, which I've cited talking about parchment barriers. But again, this is about the judiciary and the different branches of the government. He says it is agreed on all sides that the powers properly belonging to one of the departments ought not to be directly or completely administered by either of the others. It is equally evident, Madison writes, that none of them ought to possess, directly or indirectly, an overruling influence over the others in the administration of their respective powers. He's saying one branch can't tell the other branch, I'm going to override what you say you're authorized to do under the Constitution. There is no exclusive final arbiter in these types of questions, according to James Madison. And then if we go forward to the report of 1800, where he's explaining Virginia's resolutions of 1798 against the hated Alien and Sedition Acts, he says the resolution supposes that dangerous powers not delegated may not only be usurped and executed by the other departments, but that the judicial department also may exercise or sanction dangerous powers beyond the grant of the Constitution. So Madison, like many others, recognized that there wasn't an infallible branch. And in fact, if you're going to respond to unconstitutional acts, bad policies of the federal government, you can't rely on one of those branches of the federal government to police the rest of the federal government, because any of those branches could exercise dangerous powers or sanction them beyond the grant of the Constitution. He says, and consequently, that the ultimate right of the parties to the Constitution. The parties of the Constitution were not the federal government. The federal government didn't create the states. It was the people of the several states that created a Constitution and delegated powers to a new federal government. But Madison writes, the ultimate right of the parties of the Constitution to judge whether the compact has been dangerously violated must extend to violations by one delegated authority as well as by another, by the judiciary as well as by the executive or the legislature. So the parties to the compact, the parties to the Constitution, the creators, the people of the several states have the ultimate right of judging whether the Constitution has been dangerously violated. That was in the report of 1800. And again, a little further, he points out that the courts were not vested with the exclusive power. He says, however true that the judicial department is in all questions submitted to it by the forms of the Constitution to decide in the last resort. So he's not ignoring the fact that based in practice that they will have the last say on the matter in many situations. He says this resort must necessarily be deemed the last in relation to the authorities of the other departments of the government, not in relation to the rights of the parties to the constitutional compact. That means the people of the several states, from which the judicial as well as the other departments hold their delegated trusts. The people of the several states have sovereignty, final authority. No government has final authority in the American system, at least how it was supposed to be set up, not how it plays out today. And he's saying that, if you put the judiciary, these unelected, unaccountable, politically connected lawyers as the final say, then they have sovereignty and it's no longer we, the people of the several states anymore. He says on any other hypothesis, the delegation of judicial power would annul the authority delegating. The sovereign doesn't exist anymore. It is now the judiciary, and that's how we have it right now. He says, and the concurrence of this department with the others in usurped powers, and powers that are not delegated in the Constitution, might subvert forever and beyond the possible reach of any rightful remedy the very Constitution which all were instituted to preserve. They all take an oath to the Constitution, not to a particular branch of government or a political goal or philosophy or personal feelings or any of that. It is to the Constitution as ratified by the people of the several states. So back to Paulson, Michael Stokes Paulson, his great article at Constitution Center. He asks a question, who interprets? He says, who has the power then to interpret the Constitution? For Madison, the answer was clear. Everybody. And we're really talking about the oath to the Constitution, because anybody under an oath to the Constitution, they're not taking an oath that says, I'm going to preserve, protect, and defend the Constitution as long as somebody else tells me to do it. No, you have to use your own judgment in the areas where you are required to act. He says the power of constitutional interpretation is not vested exclusively in any one branch or institution of government. This is back to Paulson's article describing Madison's views. He says, including the courts, but is instead divided and shared among all of them and by officers of state governments as well. All who exercise governmental power under the Constitution share in the power and duty of faithful constitutional interpretation, with none literally bound by the views of any of the others. And this goes back again to the oath to the Constitution. Everyone takes an oath. They don't take an oath to sit around and do whatever one branch tells them to do until another branch tells them to stop. No one is taking an oath that says, I swear that I will follow all the acts of Congress that are signed by a president until a judiciary tells me not to do it anymore. That is not an oath to the Constitution. That is an oath of obedience, of bootlicking, really is what it is. It's I'm following orders, and I think they talked about that at Nuremberg. Anyways, Paulson goes on. He says, the Madisonian model of constitutional interpretive authority is one of separation of powers and the mutual checks of coordinate, independent branches of government and even of the states. No one branch of the national government possesses interpretive supremacy or superiority over the others. None is bound by the constitutional judgments of the others. And I've often said the Supreme Court issues opinions, not laws, not rulings. It's really their opinion. And that's why he's saying no one is bound by the constitutional judgments, their opinions of the others. And Paulson writes, each can and should use its independent power to check the others in order to hold all accountable and to keep the Constitution secure. And this is the juicy part. Likewise, well, it's all pretty juicy in my book. Likewise, the states as parties ratifying the Constitution. In this situation, Madison explained this in his report of 1800, which I will link in the show notes so you can read in full. He said the states in this term means the people of the states, as ratifying the Constitution, have a vital role in checking and resisting unconstitutional actions of the national government. Madison's view of constitutional interpretive authority was the very antithesis of judicial supremacy. That is what we live under today. And he goes on, and this is a great summary. The two leading features of the modern consensus, judicial supremacy and interpretive license, basically the judiciary does it all as they determine, are directly contrary to Madison's most fundamental views of proper constitutional government and correct principles of constitutional interpretation. To put it simply, if Madison's vision of proper constitutional interpretation is right, much of our modern constitutional practice is wrong. And I would say almost all of it. And I covered quite a bit of this and actually some previous work by Paulson in an episode last summer, the Marbury versus Madison myth, where I covered a number of important implications of actually looking to the oath rather than to the Supreme Court to tell us what to do. We're talking about the fact that the states are involved, that Congress, the executive branch, and that stare decisis, the idea that precedent overrules the Constitution. If the Constitution is supreme, that means precedent really means nothing. I will include that link in the show notes as well so you can check out that episode again or for the first time. Either way, it works, but it definitely is tied into this message that I'm sharing here today. And I really hope you guys found this interesting. I'm barely scratching the surface. And Paulson's article, which I will include in the links in the show notes at 10thamendmentcenter.com/path to liberty, is really worth the full read, as well as the Federalist Papers 49, 48, and the others, and the report of 1800 are all really, really good to read to understand this issue in more depth. I really appreciate you being here with me today. I think we can wrap it up right now. I hope you learned something. I hope you enjoyed this episode. And if you support what we do, you can smash that like button, leave a review on iTunes, and you can also pitch in financially and help us get the job done and reach new people every single day, which is what we're doing all the time. That's 10thamendmentcenter.com/members, where we start our membership program for as little as $2 a month. Thanks again for being here with me today. I hope you have a great weekend, and I'll see you next time here on the Path to Liberty.